Today, we will be talking about legal issues when it comes to owning and operating your own fitness facility. So I'm going to break this apart into two different videos. The first video, we're going to discuss, the different types of legal needs that you may come across, the purpose of having a lawyer or an attorney to help you, whether it be through making contracts or, defending you in litigations, things like that. And then we'll talk a little bit about contracts in this video. And then in the next video, we'll talk a little bit more about liabilities and other legal aspects when it comes to operating your own facility. So, what are the different legal services that you may need as an organization? Well, first, when you start your business, you're going to need to file as a corporation or as a business under your state and under the eyes of the federal government, right? So a lot of times you may want to hire a corporate attorney to help you out because there's a lot that needs to happen as far as documentation and legal processing is concerned, right? You need to come up with a name for your business. You need to become registered. You need to file an agent, which is typically yourself or other partners that are involved in the business. You have to write your bylaws, get a employee identification number for the IRS. So hiring an attorney is a good way to sort of process what you need to do as far as a business owner is concerned. It used to be typically that you could reach out to a lawyer to help you out with these services, but now online there are a bunch of what's called registered agents, and so one of these is LegalZoom, for example, and so they could help you analyze what you need to start your business and then help you file that documentation in order to become a business. Then you also have transactional legal services, right? So you need to develop contracts between your members, between your employees, between your vendors. It may be also necessary to apply for or renew your licensing within your state. And then, you can't just also build a business wherever. You need to have help with zoning or permits that you need within a city. For example, if you're trying to start a business, you can't just operate wherever you want to. There are permissions for where you may operate your business. If you're on, a street and you have two subdivisions, two residential neighborhoods, you can't just put a gym in the middle of there, right? So you may want that legal help to, help develop your contracts and the other things you may need to start your business. And then you have litigation lawyers, which are either going to initiate a lawsuit or they're going to defend you in certain cases. And so sometimes you may need to go after an individual or business for money owed to you, or maybe a employee or a member is filing a lawsuit against you. And so if that's the case, you're going to want to have someone to help you with that dispute. And so, you need to find the appropriate lawyer for that situation. And so, you're going to ask the question, what type of lawyer are you? As far as, baseline requirements for lawyers, it's pretty much the same across America. It can vary state by state, but all are required to pass a bar exam, and most are required to have 3 years of law school. But whatever specialization they decide to get into, that's up to them, right? So if you need someone to help, develop your membership or employee contracts, you're not going to want to go to someone who mainly deals with divorce law, right? Or someone who deals with estate law. So you need to make sure that for whatever legal representation you need, that you're finding the appropriate lawyer. And you probably want someone that's well recommended by either a peer or someone within the industry, right? And so, you need that specific experience in your type of business. So again, go based off referrals or recommendations from other business owners, and you're going to want to sit down and actually have a consultation with them, right? And so you are going to describe what you need as a business owner, what you need right now if you're just starting a business, or what future services you may require. You're going to determine those potential fees. How much are they going to charge for services. And so the way lawyers do this, it's split up different ways. It's different based on the law firm or the type of services that you need. A lawyer may require a retainer, which is where the client or the business is going to pay out a smaller monthly bill, right? So they're going to keep on paying the attorney month to month. And then, the attorney will then perform some legal services when applicable, right? So as you need them, you're going to pay, and then they'll perform their services whenever you need them to, let's say, look over a contract or come up with documentation, things like that. Then you have like an hourly rate where a lawyer is charging you per hour for their work, right? And this could include phone calls. This could include coming up with documents. And the average rate of an attorney in the United States, just across the board, not specifying, is around $225. So you want to consider, what sort of services you need, and you may want to shop around to see who's going to offer you that best price. Other services may require a fixed or flat fee, and this is typically done if the task is relatively simple, right? But again, this may change depending on the lawyer or law firm that you go to. And then you have something that's also called a contingent fee, where if you are in a lawsuit, the lawyer is going to take a said percentage of the winnings, right? So no matter if it's you win $100,000, $1 million, $10 million, the lawyer agrees to take 10% or 1/3, right? So it's contingent upon how much you win, right? That percentage is just going to be based on whatever the final outcome is, right? And so the different things that you need to consider in the fitness industry as far as legal risks are, number one, where we'll be talking about in this video, are the specific contracts, and then torts, which is basically a wrongful action, and civil liability. In what circumstances is a business liable for what happens to its members or employees? And then you also have other employee or personnel issues. So in this video, we'll talk a little bit about contracts and the different types of contracts, and then for the second video, we'll talk about the civil liabilities and employee personnel issues, right? So contracts, what are they? They are legally enforceable promises between two or more people or legal entities, right? Does not always have to be in writing. So you can have what is called an implied contract, whether it be implied by fact or implied by law. These are a little bit harder to prove because a verbal contract, of course, it's more by hearsay, right? But in order, it's always just recommended, if you are going to develop a contract between yourself and an individual or an independent contractor or another business, a vendor, etc., to always have a contract in writing, because that'll be a little bit more, I guess you could say, legally binding, and it's all laid out right there in that document, right? But in order to have a valid the contract must be an offer to enter into a contract with certain terms, right? And you need to lay out those terms within the contract. Be a valid acceptance of the offer and the terms. So both parties or the multiple parties need to agree to all these terms. Be exchange of consideration, whether that be money, goods, services, etc. Be a legal purpose, which means that it's legally enforceable if it complies with the law and public policy. And then be genuine assent between both parties, right? So you can't mislead someone going into the contract, promising them a certain good or service which is defective, or there are multiple examples, but you don't want to, enter a contract in fraud or misrepresentation. Otherwise, the contract may be void. So the following contracts must be in writing. So if terms cannot be performed within a year, if you're building a new section of your gym and the contractor says, well, we're going to need at least 18 months in order to do that, you're going to want a contract anyway, but if it's the service is over a year, you must provide that in writing. The sale of real estate, sale of personal property over $500, promise to answer for the debts of someone else, executors and administrators of estates, and then marriage. All right, membership agreements. All relationships between a health and fitness organization and members are based off the existence of a contract. Whenever you, as a patron, enter a gym facility, you're always going to need to sign up for membership. Now, it's up to the business itself what those contract terms are, but they need to be clearly worded and written out for both parties to agree on, right? Both the business, the gym itself, and that patron that's signing up for the membership, and what that membership basically includes or entails. And so you have certain things that the contract needs to lay out if you own or manage a gym, right? So number one is going to be the duration. How long is this person signing up for membership for? And how do you determine your membership? Is it annually? Is it every 6 months, every 12 months, every 18 months? You can have memberships that last 1 month. You can have memberships that are per use. And so you need to basically, in that framework of the contract, describe what membership they are signing up for. And it can change between person to person. You can have different types of memberships that last different durations, but that needs to be clearly laid out. In addition, you also need to list within that contract the canceling terms. A lot of times gyms will require that they have it in writing. Not only that, they will set a amount of time that the business needs to be notified that they are actually canceling, right? A lot of times it is 1 month in advance. Some gyms do up to 45 days or 2 months in advance. And so, if the gym decides that, okay, you signed up for 12 months and you cannot breach this contract, well, if you go in at 6 months and try to cancel, there may be a fee attached to that, right? So a lot of times businesses will not let you get out of that contract if it's for an extended amount of time, unless you have what's called an extenuating circumstance, right? So if there's a death or you are moving, and that moving thing may come with a little asterisk, because if it is a franchise gym, one of the big box gyms, they may want to see if you are going to be able to transfer your membership before you're able to cancel. So those canceling terms should be clearly defined within that contract, right? And then refunds, right? So if you do cancel for any reason, or if there is, a product with the services or the operations of the gym, how are refunds distributed? And then you also need to lay out any deposit that is necessary to be a member at that gym, and then what the automated billing entails, right? So, what day of the month will payments be taken? What are the accepted forms of payment? What is the freeze policy? If a membership is frozen, is there any fee associated with it? What's the maximum that a membership can be frozen for? And then there needs to be an acknowledgement by the consumer, by the patron, that this payment will be taken out for this amount every single month, right? And so I won't go through all of these, but when you have a membership contract, you want to make sure it includes the names, addresses, the duration, signatures, any fees, what is owed, the renewal options, the automatic payments, waivers, releases. And so the organization needs to promise that, one, as we discussed before, it's a safe and clean environment, right? You shouldn't have machines that are always broken. There shouldn't be hazards to the members or patrons within your facility. You need to keep up with maintenance and repair, and then that the staff is trained and supervised, right? And then we have the promises by the member. They're going to make timely payments. They're going to abide by the rules, right? So the contract should lay out that if a member at any point is threatening the organization, corporation, or other members, that the contract can be canceled at any point. So there are some obligations that need to be fulfilled by the member itself. They need to, make sure that they're using the facilities properly, or otherwise the contract can be terminated by the gym. They need to make sure that they're being safe, not only not putting themselves in any danger, right? So they can't just, stick their hand, in a machine unwillingly and then blame the organization. So if the person isn't abiding, again, by the proper rules of the gym won't be held liable, but also can't put other members at risk as well. And then if there are any issues, the member should notify the management of that gym, right? And so, there are different types of contracts. It's not just with members. You may also have contracts with vendors as well. And so when you're making a contract with a vendor, what should be included in there? It's one, a right to terminate the agreement. So, there should be established relationship, what goods and services are being exchanged, and for how long, and if there is a, way to stop the trade of goods, services, money at any point. Return unused goods without any charge. Be non-exclusive. Now, sometimes this does depend on the services that you are providing, right? You don't want to be stuck in a situation, sometimes where you can't sell other sports goods from different companies. If you sign a deal with one sports apparel company, then you're limited and you only need to sell their products, right? So you may want to have some leeway when it comes to vendors and different things that you use, but as far as sometimes deals are concerned, sometimes a vendor will give you a special price if you say, only buy our products for food and beverage, right? And we'll give you a discount of this amount, right? So that, again, it's called non-exclusive. So you're allowed to interact with other vendors that sell the same products, or it is exclusive and you're going to keep with that one company for that good or for that service. And then you're not to be basically financially responsible for, the damage or loss caused by the vendor, right? So if you owned a health bar and there was I don't want to come up with too gross of an example, but let's say there was a product that they sold, a drink that was contaminated with something, right? That shouldn't be legally liable by your company. It should be the vendor's fault, right? So the different examples of this when you're going to have different vendor contracts are with your pro shop, right? What sports apparel or equipment are you selling? Your food and beverage, vending machines, maintenance of different pieces of gym equipment, the laundry services, which a lot of times will be contracted out, and then health and beauty services and massage therapy, right? So you want to make sure that if any of these contractors, these vendors that you are in business with, do something, negligible, that you're not held responsible for that. And so that should be all laid out within that contract. And again, a very good idea to just consult with an attorney, right? With a contract lawyer who's going to know the language and know how not to put you or your business in harm's way. So employment contracts in most states, if a written employment contract is not in place, an employment is at will, meaning that basically the employer may terminate at will and without cause. So, Georgia is one of the states where, if at any point the employer wants to get rid of any of their employees, they have the ability to do so. And so they just need to make sure that they didn't do anything discriminatory. And so, the proof of burden, right, relies on something called absent discriminatory motive, which is basically if an employer proves that they would have let the person go in absence of any discrimination, if they can prove that, then they won't be held liable for that discrimination. I'm not an attorney, so you may want to look up more on those civil laws, but basically that's the gist, that if at any point an employer wants to let you go and it's not proven that he or she was discriminatory at any point, then they're allowed to do so. But at the same time, this goes both ways. So not only can the employer let someone go, but the employee may quit at any time without notice or reason, right? And so it's very important that to have a understanding between the employer and employee, that you lay out your policies. And so we use what's called an employee handbook in gyms, typically located at the front desk, which is going to display your policies on benefits, vacations, drug use, smoking, performance reviews, dress codes, behaviors, termination. All of these basically terms of employment are going to be laid out in that employee handbook, and that's the responsibility of the owner and the management to make sure that's available to the employee staff, right? And then a lot of times employee contracts do contain a non-competitive clause where if someone is let go, they're not allowed to work for a similar business or the same business for an extended amount of time, or in a certain mile radius, right? So many fitness contracts do say this, that for 6 months or 12 months, within a 25-mile radius or within the state, you cannot be an employer of another gym. But in the state of Georgia, there are some rules when it comes to a non-competitive clause. One, there needs to be consideration for this non-competitive clause, some sort of value for the employee not to go to a different facility. There must be, a reason to have a non-competitive clause for a valid business interest, right? Like not giving away the secrets of that gym or the way they operate and manage that facility. And then it needs to be reasonable as well. If you say that the employee cannot be work for another gym in surrounding states, right? So if you're in Georgia, you get fired, and then your employer non-competitive clause says that you can't be a employee for gyms in Florida and Tennessee and South Carolina and Alabama. That's probably not going to be looked at as reasonable, and so that non-compete clause probably wouldn't be held up in court. And then in addition to your staffed employees, your either part-time or full-time employees, you may hire what's called an independent contractor. And this may include the group fitness instructors, your personal trainers, sports instructors, and therapists, nutritionists, dietitians, sometimes chiropractors are known to be at certain facilities. And instead of you paying them a salary and having benefits and investment opportunities for them, you were just going to hire that independent contractor for them to, the gym will pay for the services and it's seen as an asset to the members of the gym, but they're not an actual employee of the organization, right? Which means they don't pay any taxes, so the organization doesn't pay any taxes for their employment. There's no healthcare benefits, retirement, vacation pay, sick leave, all of that. They're not guaranteed to any of that, and the organization's not liable for injuries or things done wrong by the contractor, the torts as they're called. But this may put you under IRS scrutiny in certain times. This has gone up recently, especially if there is considered what's called misclassification. If the business is trying to avoid paying Social Security and taxes and Medicare and unemployment, the IRS will investigate. It may cause a red flag. And most of the time when you get a red flag, it's because you had a former employee that you are now considering an independent contractor. That may be something that comes under the IRS scrutiny. And so an independent contractor, not on the payroll, doesn't receive the benefits, doesn't need to work for just you. They're allowed to work for other gyms and organizations and on their own. They are going to say when they are available for that work. So they make the schedule and you just offer the facility, and they work independently from your supervision. So they may have to abide by certain rules of the facility as an independent contractor, but not the same rules as part-time or full-time staff, right? And so we're going to end it there for now. And so we went over contracts and basically, the different types of civil services that you may need. But in this next video, we'll talk a little bit more again about wrongful actions called torts, and then civil liabilities, and then we'll talk about also, employee personnel, legal considerations, right? So discrimination, sexual harassment, breach of terms, things like that. So thank you guys very much, and I'll see you for the next lecture.